I'm just going to say good morning, everyone. I am Dr. Suzanne Ebert. I am the Vice President of Dental Practice and Relationship Management here at the ADA Business Innovations Group. I'm thrilled to welcome you to this installment of the ADA Practice Transitions Coffee Talk series. Today, our discussion will be focused on the legalities that are involved in dental practice transitions. But before we dive into our presentation, let's review a few housekeeping items for all of our listeners. First, for those of you who are listening, we do plan to offer CE for this segment. However, it is pending at the moment, and it will only be available to those who are listening to the live version. So be sure to keep an eye on your email for details on how to claim your credits. Second, this webinar is being recorded and it will be made available to you. So look for an email next week with instructions on how to access the webinar. Finally, if you have questions during the program, we encourage you to submit them through the Q&A function that's found at the bottom of the screen. We will answer as many as possible during our question and answer period, and any outstanding questions will be addressed in a subsequent blog post. So be sure to monitor our blog that can be found at adapracticetransitions.com. And now for the main event. We're joined today by Mr. Charlie Douglas. Charlie attended the University of Florida Warrington College of Business, where he graduated summa cum laude with a degree in business administration. During law school, he served as editor-in-chief of the Florida Law Review and graduated second in his class of 211 students. Charlie focuses his legal practice on business matters, including succession planning, buy-sell agreements, real estate law, and estate planning. Charlie has extensive experience with litigation and helps his clients avoid costly trips to the courthouse. His passionate representation and advocacy for his clients led Florida Super Lawyers magazine to recognize Charlie as a rising star. Now, this is an award that's reserved for less than 2.5% of attorneys in Florida under the age of 40. Charlie is the current board chair of the Putnam County Chamber of Commerce and volunteers with other community organizations, such as the ARC, Putnam First Cancer Fund, and the Boxer Aid and Rescue Coalition. He's an instrument-rated pilot and in his spare time enjoys flying, hunting, fishing, and spending time with his beautiful wife and 3 adorable children. Welcome, Charlie. It is great to have you with us today.
Thank you, Dr. Ebert. It is great to be with you and everyone who is attending by Zoom. I hope that you've found your warm cup of coffee and settled in for a very fun discussion this morning about how we can take the pain out of dental practice transitions. This is an exciting topic to discuss. It is a big topic nowadays with a large segment of dental practitioners who are going into retirement and a lot of new dentists who are coming in and taking over. So let's dive in and talk a little bit more. Again, this is my information. If you would like to contact me, please feel free. That's my email address there on the screen and my telephone number. And if there's anything I can do to help with a particular matter that you may have, please feel free to give me a call. I'm located here in Florida, but I have colleagues all across the country, and together we'd be able to help in any way that you need. Again, this presentation does not give legal advice or create an attorney-client relationship, but is meant to open a dialogue and give some pointers and some items to think about as you consider a dental practice transition. So a famous quote is a journey of 1,000 miles begins with a single step. And this is something that I think is applicable for this conversation because whether you are a potential buyer or a potential seller of a dental practice, by the end of the transition period, you probably will have felt that you have traveled 1,000 miles. And it all has to begin somewhere. But the goal is that after that 1,000-mile journey of a dental practice transition, that you not feel too beat up. We are here, the experts are here, your trusted advisors are here in order to make the transition as painless as possible. And a lot of times people use root canals as an example of how something or how painful an event is in their life. We do not want the dental practice transition to feel like a root canal. These radiographs here are actually of my teeth. My wife, Bethany, is an endodontist, and while she was a resident, she performed a root canal on me, and I'm happy to report that the root canal was successful, and honestly, it was not that painful. Everybody hears about root canals and how terrible they are, but at least in my experience, this was a procedure that was not bad at all. And one of the reasons is because dentists in their toolkit have ways of taking pain out of dental procedures. And really, that's what we're here about this morning, is what can we do on the legal side? What are some of the ways in our toolkit that we can make the transition of a dental practice as painless as possible? And the way that we do that primarily is to assemble a very good team and assemble that team from the outset. When you're having those early discussions with a potential buyer or a potential seller, you want to be very upfront that you have a team of folks, and that that you are gathering a team of folks. You have an attorney, an insurance agent, a banker involved, an advisor, realtor, accountant, all of these people who will come together to give you the best advice possible during that dental practice transition. And unfortunately, sometimes dental practice transitions can get a little sideways because these experts are giving advice going in different directions. If you work with an experienced team of dental practice specific transition specialists, I think you will find that that team is a coordinated team, and make sure that everyone is pulling the wagon in the same direction. You want that team, if you work with experienced advisors, you will have that benefit where everyone stays on the same page from the beginning all the way through the end at closing. So I would make a small amendment to that quote of a journey of 1,000 miles begins with a single step. And I just would add, and a letter of intent. That's really where the rubber meets the road on the legal side, is with a document that we call a letter of intent. And this document will be usually the first written instrument that enters the scene in the conversation between a potential buyer and a potential seller. Up to that point of the letter of intent, there will have already been multiple conversations, either over the phone or in person. And hopefully at that point, the buyer and the seller have had good opportunities to share their individual philosophies about treatment and care of patients, and also the philosophy of the firm. What is the type of dental practice? Is it mostly cosmetic, restorative? Is it specialty? Is it insurance-based or more fee-for-service? How many patients? Is it a settled book of patients, or is it a growing practice where a lot of new patients are coming in every day? Do you refer out a lot of your specialty work, or is that something that you do in-house? These are a lot of the questions about the philosophy of care and for treatment that hopefully is the underlying foundation for positive conversations that lead the parties to this legal document called a letter of intent. And this is where we start writing what those elements are that are going to be the foundation and skeleton of the purchase and sale agreement as we move forward in the process. And in the letter of intent, it's common and should be expected that a lot of different items would be addressed. First is the structure. How will this potential buyer be coming into the dental practice? Of course, what is the price going to be? What are the assets? The tax allocation of how those purchase proceeds are spent. Real estate related questions. Non-compete clauses, employees, continuation of treatment, and a closing date. And so at this time, what I'd like to do is to take some of these elements and talk about them individually so we can take a little bit of a deeper dive. The first is structure. How is that a new person who's coming into the dental practice going to be treated? Is it going to be a 100% purchase and sale? So that buyer comes in from day one and they are there by themselves and they own the practice from that point forward 100%. That is a common scenario, a common structure type where the buyer will come in. And we'll talk a little bit later about whether the seller stays around for some type of a transition period. But most circumstances, there's going to be some type of a outright purchase and sale of the practice. Another type of structure arrangement is a percentage buy. This is typically found in a scenario where maybe a person is newer to the market. They don't know as many people. They want to wade into the waters instead of dive in head first to the deep end. And so there will be a percentage buy-in, but still an expectation of a full buyout later down the road, whether months or years to come with a percentage buy-in. And then another option is an associateship with an option to buy. This is commonly found with younger dentists who maybe have just graduated dental school and are coming into a practice. They don't have a patient base. They're maybe newer to the geographic market. They're still determining what their philosophy of care will be. And again, this is a way for them to see what the lay of the land is first before they make that final decision of a 100% purchase and sale. So those are the top three types of structure that we normally see with a dental transition. All right, then we come to a price and valuation. And I can't stress how important it is that early on in those conversations, the buyer and seller determine what that price will be of the dental practice. There are a lot of different variables that are at play, and there are a lot of different methods to come to a price. And there are a lot of different experts that you can go to arrive at a price. A lot of different factors, including, is this going to be a cash purchase, or is there going to be some type of a loan? And if a loan, is it going to be a private money loan? Is it going to be a conventional bank loan? Is there going to be some type of an SBA component to it? And depending on which one of those factors are at play will be very important how the purchase and sale agreement is structured later. But I have seen a lot of these transitions go sideways later because there was not that heart-to-heart conversation about a pricing and a valuation method from the earliest conversation. And that's another important point to bring up, is that you want your team of experts and advisors to join from the very beginning, because once you have that expectation in place, then it's not a startling event when later down the line, one party says, okay, well, now is when I'm going to have my lawyer step in. It may send an unintended tone or message to the other party later in the process of, well, how come the advisor was not involved from the beginning? So having everyone at the outset helps in giving direction on where you can go to get these valuations performed and how we can help the conversation with the parties about a price. All right, and there are a few different types of valuation methods. One is a market value method, and the best way to think about this is kind of like a real estate home purchase, where there is a market, there are comparables of other locations or houses in the market, and based on those comparables, there is a value assigned to the subject matter. And likewise, in a dental practice transition, a market value would look at the sale of other dental practices to try to see what a fair market value would be, considering all of those other practices who have sold in a similar geographic region and within a reasonable span of time in the past. So that's called the market value. Another approach is called the income approach. And that's really looking more specifically at the financial documents from the individual practice. The revenues, what are the sources, balance sheets, profit and losses, what are the earnings, what are taxes, any depreciation, amortizations. So the income approach takes in a lot of factors with a specific individual practice, and then give some credence to an industry standard or multiplier on what those numbers will look like at the practice level, combined with the national statistics, and the product of those numbers would be what the value would ultimately result in an income approach model. And then another lesser common approach is an asset value approach. And this is looking at all the individual assets inside the practice and then accounting for liabilities and then arriving at an overall value with that type of a calculation. So market value, income approach, asset value, the dental practice valuators are going to be looking at some, if not all of those, to try to come up with a specific number, or at least some type of a ballpark figure that, depending on various factors, the buyer and seller can agree to operate within as they go through the process of drafting the final purchase and sale contract. All right. So next up is assets. What are the assets of the dental practice? That's a big component of the letter of intent. Accounts receivable, what's coming in. If you are more insurance-based, what is the lag time between treatment and when you are ultimately reimbursed? Or is this a fee-for-service practice where you collect payment immediately? Or do you have payment plans for patients? All those types of things are discussed with accounts receivable. Equipment. Is this an older practice where you're still doing films with older x-ray equipment, older dental chairs? Or is this a practice that has invested heavily in brand new state-of-the-art equipment with all the different bells and whistles that you see? And that will have a big impact on the value of the practice if there's going to be 100% buy-in. Also, fixtures, things that are connected to the building itself, like lights or the chairs or carts or equipment. Those things that are actually connected to the building is what is a fixture compared to equipment. Also, inventory. Things that are in your supply closet. How much do you stock? What type of inventory system do you have? Do you keep a lot of inventory, or is it more kind of a just-in-time approach where the inventory arrives as soon as it's needed? What is the value of that inventory? And I believe it's very important from the outset to start an exhaustive list of equipment, fixtures, and inventory. The more specific you can be, the better from the very beginning. Also, I've seen practice transitions go sideways because of exactly what was going to go along with the transition and what was not. Then there are what are called intangible assets. These are things like goodwill, intellectual property, and patient lists, email addresses of patients, regular mailing addresses of patients. In this day, where marketing is more and more important, with dental practices, those lists, email and regular mail, are increasingly important. I'll talk more about intangible property in a moment. All right, now let's talk about real estate, the place where the dental practice is located. Is there some type of a lease that is involved? If so, I would recommend that you involve the landlord immediately. They will usually keep confidential the idea that you are considering a dental transition, but you're going to want in writing pretty soon some type of an agreement that the lease that is currently on the books can be assigned to the new buyer. And that's going to be important for the buyer side as well, that by signing or by going through with the dental transition, that it's not going to negatively affect the lease. Obviously, there's huge investment involved inside the walls of a dental practice, and you don't want to be kicked to the curb by the landlord by failing to consider the lease up front. And then also, if it's going to be a purchase of both the dental practice, the operations, but also the dental building and the land. You could go either way depending on how the seller has it structured. But if there's going to be an ultimate purchase, then there would need to be a separate contract for the real estate itself. And that opens up a whole other discussion that we could have an entire coffee talk about. But just know that there are a lot of other factors involved if the building and the land are coming along with the transition itself. All right, and there are different ways that you can title real property in individual or corporate names. It would be very rare that I would ever recommend holding title in an individual name just for liability purposes. It's extremely helpful to have that extra layer of a corporate shield. You don't want a situation where you're sued because of something to do with the premises, not because of any dental related care, but because of something to do with the premises, a slip and fall or something like that. And having a person sue you individually is never a good thing. So having that extra layer of protection so that a potential plaintiff would not be able to pierce the corporate veil is important to think about early on as you're going to decide how to title the real property. Then there are other forms of ownership. If you are owning the property with someone in addition to yourself, like tenants in common, joint tenants' rights and survivorship, and tenants by the entirety. And those are important, and all of those have different effects depending on when one of multiple people dies, and then how the ownership structure is affected for those who survive after the death of one of the owners. All right. The next thing that's very important in the letter of intent is taxation. And again, this is really where our colleagues who are CPAs pick up. I don't want to go too far into their realm, other than to say that there is a difference between ordinary income and capital gains. And most intangible assets are taxed at a capital gains tax rate. And the reason this is important is really for sellers. When you sell a dental practice, the seller is going to want to have as much as possible allocated toward the intangible assets, just because that amount of the allocation for the overall sale is going to be taxed usually at a lower rate, assuming that the dentist, the seller's ordinary tax income rate is higher than their capital gains tax rate. There are also depreciation concerns that are at play that the CPA will be able to give you additional advice about. And it is for that reason that I always recommend that we involve on that team of advisors a dental experienced CPA. Also important to the letter of intent is the closing date. And this is important because you don't want to have a closing date too soon and then have to continue to go back and back and back to the seller for extension after extension after extension. You don't want a closing date that's going to be too far out in the future because the parties will tend to lose momentum or potentially interest or motivation. So you want a closing date that's going to be in the middle, that's just right where there's enough time to maneuver and get everything in order and do the due diligence and have all the documents completed and completed well, but not too far out that you're going to risk compromising the deal overall. So a closing date is something important to think about. And also in conjunction, if a bank is involved or the SBA is involved, you want to know that early on, because that will also significantly determine the amount of time that's going to be required. And it helps to have the expectations up front with the seller and also the buyer, that there could be many, many months involved in going through the bank, the underwriting, loan processing procedures. All right. So that as a whole is the letter of intent. It is a non-binding agreement, but it still helps to get the parties on the same page, so everybody's singing from the same sheet of music, and that later, if anybody tries to veer outside too far, everyone's attention can be redirected to the letter of intent, and everyone's expectations will remain in line. But after that point of the letter of intent, we move then into the phase of drafting a contract. And there are basic elements involved with the contract drafting. Obviously, there's a lot with the meat of it, like the parties and the price, closing dates, escrow accounts, and all those types of things. But I also wanted to touch on some of the more elemental, basic matters involving contracts, such as the introduction, who are the parties, the date of the contract, certain recitals, information about the purpose of the agreement, how the structure is going to be assigned, acknowledgement that promises and conditions of the contract represent valid consideration. You're looking at confidentiality of the agreement. This is really important for both sides to keep this confidential agreement in place, because if word were to get out in the community, it could have potentially negative effects on the dental practice or the parties involved. Assignability is something that you want to consider, because under most circumstances, a seller would not want to assign to the buyer the ability to give the buyer a potential to find a different buyer. Because at this point in time, you have determined that the philosophies match, that the patient is going to like the new dentist who's coming into the practice. So a lot of times, a seller will not give the buyer an assignable interest in the contract. And then amendments or waivers are things that should be considered in the purchase and sale agreement.
Right, for takeover. Midwest tried to acquire a practice in Viroqua. They did, and they were in business for a couple of years, and more than that probably, but they've recently closed their office there. Viroqua's a town right down the road.
Okay, looks like we have somebody who's come on.
Golden opportunity for
Kathy, could you go ahead and mute
they want
that participant, please?
Theater and art and restaurants. That's La Crosse, and that's 40 minutes away. And there's no sign-up bonuses and all kinds of things. That's the other. So anyway,
all the participants are muted, Suzanne.
Okay, thank you. I'm sorry, Charlie. Please continue. If anybody has questions that are specific questions, please use the Q&A feature at the bottom, and just make sure that your microphones are muted. Thank you.
Yeah, no worries. Thank you. Okay, so another type of basic element is the notice provision. Who will be put on notice regarding any events surrounding the contract terms, and then also choice of law. And that pretty much means which state laws are going to apply to this contract. And under most circumstances, this will be the state in which the dental practice is located. And then venue is aware if there's any type of a lawsuit involved where the enforcement would be brought. Nowadays, there are usually arbitration provisions in contracts, so that if there's a dispute, instead of going to court, the parties agree in advance that they will submit their dispute to an arbitrator and have that determined or decided privately with an arbitration panel. And that takes care of the second or the issue here at the top, which is arbitration. And then construction of the contract, headings, execution and counterparts, gender, plural references, etc. Also, severability. If there is a portion of the contract that later is deemed to be invalid, then that portion of the contract can be severed and still allow for the entire contract as a whole to remain. So that's what severability means, that a portion, if any portion is considered to be invalid, that portion can be excised, but the rest is still okay. And then termination of the contract, and certain events occur. So as we were discussing about different items to think through on this particular coffee talk, we wanted to speak briefly on estate planning. And this is important for dental practice sellers, especially, but also for dental practice buyers, making sure that the estate is in order so that you can sleep easy at night knowing that your particular personal legal affairs are in order while you are remaining focused on the dental practice itself. So there are different kinds of estate planning. There's very simple on one side of the spectrum, and also some types of estate planning that are very complex. And depending on your individual situation will determine, and what your individual goals are will determine what you want to accomplish and the types of legal documents that would be required for your particular estate planning. I guess the simplest form of estate planning is doing absolutely nothing. And there's a legal term for that, and that's called intestate succession. If you die intestate, that means that there's nothing that you put into place prior to your death to tell the courts or your family where you wanted your assets to go after you died. And so in that circumstance, the state legislature decides, and they pass laws or statutes that will determine where your assets go after your death. It is as if they could reach down into the grave and ask one last time, what would you have wanted to do with your assets if you could tell us? Of course you can't, but the legislature makes their best decision on what that answer might have been. And sometimes the legislature gets it right, and many times the legislature gets it very wrong, especially in blended family type of situations where there could be a step-parents or stepchildren involved. You definitely want to have estate planning in place, because the results of intestate succession could be disastrous for your family unit on what you would have wanted to happen had you had your estate planning in place prior to death. So another simple form of estate planning is called a will, a last will and testament. Most everyone is familiar with that type of an estate planning document. The good of this is that a will helps distribute assets. It is a way to determine in writing and let the world know where you want your assets to go after you pass away. It names a PR, or personal representative. This is the person who used to be called an executor or an executrix. And the role of that person is to dot the I's and cross the T's of the estate to wrap up everything after you pass away. They help marshal all the assets and help dispose of or take care of any liabilities that might exist at the time of your death. And then also a will is able to name a guardian. If you have children involved, this is especially important, so that if you pass away simultaneously with the child's other parent, that there would be someone named that the court can look to and say, this is the one, this is the adult who is the preferred guardian to raise our children and to have those financial decisions relating to assets that would benefit the children who survive. The disadvantage of a will, though, is probate. Wills have to be probated. So any nosy neighbor can go down to the courthouse and pull the file and see what's inside the will, how much money you had, where the assets went, how much you gave, and to whom. And that is why we know a lot about people like Tony Soprano, who had a will in New York. Or compare that with the famous singer from Minneapolis, Minnesota, Prince. He died with nothing. That was an example of dying intestate succession. And in both of those examples, dying with nothing or dying with the last will and testament, both of those have to go through the probate process. And then most of you have heard of what are called revocable trusts or living trusts. And these are legal instruments that are available where a grantor or a settlor, like yourself, who's implementing the trust, is able to create a legal shell where assets are put inside of, so that after you pass away, we can avoid probate if the document is drafted correctly and if it's funded properly. The revocable trust will have a trustee, and in these, you will have complete control of your assets during your lifetime. And only after you die, then would the successor trustee who you name have the ability to distribute assets according to your wishes. But during your lifetime, you have complete control. And then, of course, the revocable trust lists beneficiaries on who will receive assets and when those assets will be received. These documents are great for lawyers because it can provide a lot of flexibility to accomplish our client's goals. So if you have a child who you may have some concerns about receiving money early on, you can structure the payments of when those assets would be delivered and under certain conditions. So the revocable trust is very helpful in providing for different contingencies to accomplish your goals. The good of these types of revocable trusts are that we can avoid probate. Again, if it's drafted correctly and funded properly, then there would be no need for a very long, drawn-out, and many times expensive probate process. You get to keep control of the assets in your lifetime, but you just have to make sure that they're properly funded. There are also irrevocable trusts that are available, and this is a document that is used more for situations where an estate tax threshold might be met. And these are usually higher, like around $5 million or upwards of $11 million if you're married. If your estate is knocking on the door of those numbers, then many times irrevocable trust can be used to lawfully shelter assets off of the radar screen of the IRS. So that's something that you would want to work in conjunction with your CPA and your attorney well in advance, prior to your death, so that these items could be drafted and implemented in such a way to accomplish the goals that you have to avoid estate planning, or is commonly referred to as a death tax. So, there are also supplementary documents that are extremely important during your lifetime. They are only applicable during your life. At the moment of your death, they cease to have any authority or power. One of those is called a durable power of attorney. One is called a healthcare surrogate, and the other is called a living will. And all of these documents work in a coordinated fashion, and you want them to be sure that they are supplementing each other correctly and that they do not have any internal conflict. So a healthcare surrogate is sort of like a durable power of attorney where you name someone to make decisions on your behalf, but it's primarily focused on those healthcare-related decisions like consent for medical treatment, gathering HIPAA-protected medical records, and also transportation between medical facilities. A living will is something that applies to an end-of-life decision. Since I'm here in Florida, many of you may remember the case about 20 years ago with Terry Schiavo. She was in her 30s when she had a traumatic brain injury, and she was left in a persistent vegetative state. Her husband said, "I know my wife and she would want to pull the plug." But her parents came in and said, "No, we know our daughter and she would not have wanted to pull the plug." And therein started a huge court battle that went up and down all the appellate courts and in between, and just consumed an incredible amount of judicial resources, private resources from the families and the parties, and a considerable amount of time. And all of that could have been avoided with a simple document that we call a living will. So I'm a very strong proponent of having these ancillary documents in place up front. And the last one is a durable power of attorney, and it's a hugely important document, and it comes with a tremendous amount of power. When you name someone to be your power of attorney, they have a lot of control and an ability to act on your behalf. So you really want to be sure that you trust the person who you name as your power of attorney. But the reason I believe it's so important is because in its absence, if you do not have a durable power of attorney, then the only other option is to go through a guardianship proceeding, and those can be very long and very costly for your family. And so to have that power of attorney in place at the outset is just another layer of protection for your overall estate. So I've come to the 37-minute mark, and I will, I think I had 35 minutes, so I apologize for going 2 minutes over. But at this time, I'll be glad to take any questions that you have or any remarks that you want to make, and see if we can help. Dr. Ebert?
Thank you so much, Charlie. That was incredibly informative. And I actually have a number of questions that have come in. So
Great.
I'm hoping that we can get to all of them.
Okay.
We are going to start with, how many hours would I be expected to be billed to draft a letter of intent?
That's a good question. A lot of times the letter of intent can be done if the parties have done their homework in advance and can give some type of a thumbnail sketch of what the agreement is on a napkin or a yellow piece of paper or a quick email. The letter of intent can be drafted in somewhere between 2 to 3 hours, I would say, is a good point of reference. And most attorneys, well, there's a very wide range of attorney billable hour amounts, depending on where you're located in the country. So either the attorney would charge an hourly rate, or they would charge a flat fee. But under no circumstance could I see a letter of intent costing more than $750 to $1,500 if it's the letter of intent only.
Thank you. In kind of keeping on that same theme, who generally has the contracts drawn up? Is it the buyer or the seller? And do they ever split the costs?
Yes, and I hate to give a lawyer's answer, but it depends. And I've seen it both ways where the seller's attorney jumps in. And a lot of times this is relationship driven. And so if one of the parties might have a very strong relationship with an attorney because they have one in the family, or they have a next door neighbor, and then they will immediately bring in that attorney, and that attorney just starts right away. But if the parties are on equal footing and maybe neither of them has a strong relationship with an attorney at the outset, it's probably good to go ahead and get attorneys on both sides from the get-go. And then they can determine who wants to take the lead on drafting the document. And whoever's going to be drafting the document is going to usually charge more money because there's more involved with putting pen to paper than receiving the document and reviewing it second in line behind the first attorney who drafted it and just giving edits and reviews second in line. So yes, the attorney who's drafting the document is usually charging more, but would also be doing a lot more with the drafting and the closing of the transaction typically. And it depends on the parties. And yes, I've seen where they split the cost. But even in splitting the cost, the attorney is representing usually one party. There are circumstances where there may be some type of joint representation, but that's rarer. If there is one attorney involved, there may be an ability to communicate and have good conversations and dialogue at a conferencing table. But depending on which state that you're in and the rules of ethics for the attorney, it may be that the attorney is technically only able to represent one client at a time.
Okay, here's another one. I am looking at purchasing a practice, but I've been an associate in the practice for 3 years. The owner has hired a dental broker to manage the sale. Do I need to hire an attorney and an accountant?
I would recommend yes. I think it's always a good idea to have people who are in your corner, who are advocates for you, and who have your best interests at heart. So I believe that in the long run, that because a dental practice purchase is usually the largest purchase someone has ever had in their life, that you spend a little extra money, and you're talking, very small percentage points of cost as it relates to the entire cost of the overall transaction. That it's well worth it to have someone looking it over on your behalf.
On that same note of dental practice brokers, if I am using a dental practice broker to sell my practice and they have delivered all the contracts to me as part of that 10% that I'm paying, do I need to hire a lawyer and an accountant or not?
It's up
I have
to
some pretty strong feelings on this one, Charlie. Let's see if we're on the same page.
Yeah. Now, depending on which broker that you're talking to, most brokers are not lawyers. So although they may have form documents in their arsenal that they may be able to give to you in kind of a boilerplate form and to help get your mind going on different elements of a contract, every deal is different. There are so many different factors involved that I always believe it's important to have someone with a legal set of eyes who's trained to be able to make a deep dive into the particulars of the contract, who can immediately identify any potential landmines or roadblocks along the way. And a lot of times people think, oh, if I get a lawyer involved, it's going to slow things down. I found that's not the case. If anything, a lot of times having a lawyer involved can speed things up. You say, hey, here are some factors you may not have considered. Let's go ahead and get them on the table now. Let's talk about them. Let's make a decision. And they can help move the train along the track even faster than you imagine.
Okay, so here's another one. When do we do due diligence? What does that mean?
I've seen that come in many different forms. A lot of times when a buyer and a seller are starting out the discussion early on, a seller is very transparent and will hand over documents willingly from the get-go, even before the advisors come in. Other times, a seller is a lot more private and will not give up those documents until certain confidentiality agreements have been taken care of and that there's a purchase and sell agreement in place. And a lot of times if there's a conventional loan involved, then this will be driven by the bank, because the bank is going to decide the level of due diligence and the amount of particulars that they want to see.
Okay, what are the legal concerns for the selling dentist once they leave, and how do they protect themselves?
That's good. And there are a lot of different things that you would want to consider. For a selling dentist, the allocation of the sale proceeds is extremely important because of the way that they are taxed. If there are any potential claims, whether it could be, like I said, property damage related, where someone comes onto the premises, they slip and fall in your waiting room, how is that potential claim going to be handled after the departure? Because these lawsuits can last for years at a time. Well, if there is a dental transition happening simultaneously, you're going to have to figure that out. You want to talk to your insurance agent about that. Also, on the potential dental malpractice side, if there is some treatment went sideways and you're in the midst of a dental malpractice claim, what type of tail coverage or E&O coverage that you have? Is it occurrence-based? Is it claims-made type of a policy? What type of tail coverage is going to be available for you? So liability issues are there. Also, at the time of closing, there are a lot of warranties and representations that are made from the seller. and you want to know what you're saying. When you're making these representations to a potential buyer, the buyer could really hold your feet to the fire after the sale. So you want to have someone to carefully review with you what those warranties and representations are, so that when you sign and you leave the practice, that you can truly enjoy your retirement and not have these concerns that continue to plague you as you're trying to enjoy those golden years of retirement.
Well, this kind of follows right along with that. So what questions should I ask the lawyer so I can be confident that they are able to handle my transition and won't overcharge me?
That's good. I always recommend having that fee discussion up front. The buyer and seller have usually already waded into the waters already, and let's face it, it's a little awkward when you're trying to determine what the price of the dental practice is. But it should not be difficult to have that upfront conversation with your trusted advisor about what the fee is going to be. A lot of advisors charge a flat fee, which can be good for the parties, because sometimes these things can last a long time with multiple extensions, and there's a lot of work that goes into it. And the parties can have a cap on what that advisor fee will be. And other times the parties would choose to go with some type of an hourly rate. But in the CPA world and the legal world, really that is how the advisors are compensated, with a recognition of the amount of time that is committed. So it's a mixed bag on the law firm and the lawyer about whether they're going to charge a flat fee or some type of an hourly fee. But you can always ask for an hourly fee with a particular cap involved or something like that. But I would say most times these advisors, if you connect with a reputable advisor who's had experience in the dental transition world, have a good reputation, and they're going to treat you right because they want to protect that good reputation for future relationships down the line.
Well, what questions should I ask my lawyer to be sure that they're experienced with dental transitions?
Sure. You want to know their background, their experience, what are their educational credentials, what type of dental transition practices have they done in the past? Are they more focused on general practice type transition or specialty transitions? Ask for references even, and get a good feel. You can have multiple conversations. By no means do you have to hire an advisor on the first conversation that you have with them. You can get to know them, get to know their personality, and you want someone who's going to match that personality. This is a very good point that you bring up, Dr. Ebert, because the personality of your advisor helps to be in line with the personality yourself. And the way I can explain that is, your advisor is going to be having discussions with the other party. And so if you're a person who approaches things with, in the South, we have this expression, we better to approach it with honey than vinegar. So for me personally, I'm a person who treats everyone with respect, and I try to come in with that honey approach first, keep things very positive, professional, and not bring in the vinegar. But if you interview a potential lawyer or a CPA who is a very hard-nosed type of advisor, and that type of a personality may come across to a potential buyer that they're communicating with, it can leave a really bad taste in their mouth, and that potential buyer will assign the personality type of the advisor to you, the seller, and it could compromise the deal. So you want the people on your team to be of the same mindset. Just as you want a potential buyer who has the same philosophy of care, I submit that you want an advisor who has the same philosophy as you as well.
Makes it so much easier when everybody's on the same page, doesn't it?
Absolutely, no doubt.
All right, so I think we have time for one more. So I'm going to flip a little bit, and we're going to talk about a new grad. Okay. So the question is, I just graduated from dental school. How soon should I think about having an estate plan drawn up? Do I need to have a lawyer help me, or can I use the online resources that are available?
Great question. I do get that a lot. And I'm an advocate for getting the estate plan done, early on in your life, because no one is promised tomorrow. You don't know when that appointed day will come. And so to at least have some basic estate planning documents in place at the outset is so important. Even if you're not married yet and you don't have any children, maybe you have a trusted parent or sibling or friend who can help with those decisions, then that if you are incapacitated, that someone is there to help make decisions for you, or if you tragically pass away, how to handle your affairs. These are, especially with a younger dentist, when you may have liabilities like student loans, or you just purchased a new house, and they're going to be liabilities of your estate. And how those liabilities are handled after you pass away are things that we would want to address for you in your estate planning documents. So I do recommend go ahead and get those done at the outset, and it will serve you well for the long term. And later in time, these estate planning documents are flexible. So nothing is written in stone unless you die, of course. But as long as you have legal capacity, you can always amend. Families are always in a state of flux because of marriages or childbirth or adoptions, people going out of the family because of divorces or deaths. And we can always make amendments to the documents or create new documents if we need to have a little bit more advanced estate planning, depending on the station you are in life. We can meet you where you are at that particular point along the path and develop the documents for you there.
Charlie, I cannot tell you how wonderful this has been. The information that you've provided today has been invaluable to our members, and we just really appreciate everything that you have done for us.
It's been my pleasure. Thank you.
We do have your contact information, and I understand you are willing to take questions after the fact, and any questions that are outstanding, we'll be happy to address in a subsequent blog post. I just want to remind everybody, keep an eye on your email so that we can keep this discussion going. Charlie, thank you so much for joining us for our coffee talk. You were amazing.
It's my pleasure. Thank you all. Have a great weekend.
You too. Bye-bye now.